Folks, if you're looking at the record, we're going to be talking about guardianship terminations and orders, not de facto custody. That's merely on there for information. It's a bill we looked at last year, so our focus for the next little bit will be guardianship and terminations.
Brian? Mr. Chairman, this bill draft 1926. It's a direct response to the committee's discussion in Orland. The direction was for a bill draft that would provide a clear procedure for courts to use upon a parent's petition to terminate guardianship, as well as giving courts more flexibility to enter orders related to the termination of the guardianship. Beginning at the bottom of page 1, this bill draft creates a new section 331107, which provides, beginning on page 2, a list of factors that the court must consider upon the filing of a petition for termination of guardianship by a parent. Those factors are listed on page 2 and 3, and then on to page 4. On page 4, line 10, subsection B provides that the court may consider those factors in subsection A without first making a finding of parental fitness or a finding that the guardianship is not necessary. Beginning on line 15, page 4, this is the part of the bill draft that gives courts more leeway in what orders they can issue upon for the termination of the guardianship. It allows the court to establish an integration plan or graduated visitation for the parent. It allows for the granting of visitation rights to the guardian. It allows orders that would require the parent to attend classes or seek treatment based on whatever contributed to the necessity for the guardianship. On page 5, line 10, provides that the court may appoint a guardian ad litem for the child, and subsection E, page 5, line 16, provides that the proceedings are governed by the rules of procedure and evidence. Section 2, at the bottom of page 5, going to page 6, these are more, these two amendments are just conforming amendments. Paragraph 8.5 is just an amendment that for termination of guardianship that termination can take place after the court considers the factors that are created in this bill draft. The amendment to 331105 just clarifies the filing of a petition or termination or modification of guardianship on the ward. The new language for that subsection C, which is new, allows a parent to, or any petition to any party to the petition for guardianship, and move to either modify or terminate it at any time. With that, Mr. Chairman, I'm happy to answer any questions the committee may have.
Committee questions? Staff? At this point? All right, thank you. Appreciate that. Okay, let's, we've got two speakers that are on our schedule. And if we can start out with Professor Waffle. You can certainly speak from up here if you'd like, at the table. That'd be great. Dr. I'm going to say that. Barofio, feel free to come up and join us. And the mic works on the table, just make sure it's near you. It'll pick up. Thank you very much.
Good afternoon, Chairman Christensen and esteemed members of the Judiciary Committee. I'm very pleased to be here from Jacksonville, Florida. The Guardians as Protectors contacted me and asked me to look over the bill and to come and to give you their insight and a few in support of the termination of guardianship bill 331107. 107. And what I would like to do is to simply recognize that in a termination of guardianship setting, we are dealing with a situation where a parent has decided that they are no longer capable or able to carry on the obligations of parenting. So the children, either through, as you know, a voluntary or an involuntary termination process, guardianship process, are given over to, typically in this instance, grandparents. And because the sense is then the setting will provide to them a loving, stable home with continuity of care. So as we look at this statute, my sense is that it does a good job because it adopts and thinks about the best interests of the child. It identifies mandatory factors, so there will be some consistency in the treatment of the termination cases. And it also focuses in on, as I said, the best interests of the child. So the statute does a fantastic job of putting the child at the center of the consideration. When I looked at the statute, I felt that I might just advise to the group very minimal changes. And I had thought that it might be helpful to expressly identify some of the past history of mental illness. So I'm not sure if you have a copy with revisions on it, but on page 2, in Roman numeral small 3, on line 13, I had thought it might be helpful to think about the history involved with respect to why the guardianship was put in place, and to particularly reference the abuse of drugs, because that is a concern of the guardians as protectors. And the statute would be strengthened by at least having that as a mandatory consideration. The second revision that I thought might be helpful is to think about the impact expressly if there would be harm in terminating the guardianship. And that provision is outlined on page 4, line 6, dealing with the impact of modifying the guardianship. Once again, it is a friendly suggestion. It is in no way meant to take away from the good work that the committee has done. The final change that I thought might be helpful is to think about a way to deal with the burden of proof, so that if there is any risk of harm arising out of an erroneous decision, that risk is not placed on the welfare of the child, that in fact that risk then is borne by the parent who is seeking to terminate the guardianship. And once again, these were all just thoughts I had to strengthen the proposed legislation with an eye towards protecting the children around them. So those were the 3 thoughts that I had. My hope is that this bill will go forward and continue through committee and be voted up. And I wanted to just be here as a voice in support of the bill and the legislation. And I'm happy to answer any questions that you might have, or to move on to the second speaker.
Let's go ahead and talk about your language suggested here. Committee, everybody has a copy of the bill with the written in amendments, or written in language. Anybody not have this copy that has the handwritten? All right. You have, it's like a little short on those.
Mr. Chairman, I did put, I apologize, over the lunch hour, I did put a copy in provide each chair at this point. I know there's a lot of paper floating around, so.
Should we find one with some of the notes got it? Anybody else need a copy? All right. Let's go over and just take a look on page 2, that new language. And staff, her and Brian, appreciate your input or questions on this one also. New language starting after guardianship, including the following special factors: history, mental illness, domestic violence, criminal behavior, and association with the criminals, child's abandonment, abuse, or neglected, habitual drug addiction. Any other questions before we go to staff? No input. Representative.
Thank you so much, Professor. I really enjoyed reading your law review article, the best interest of the child. Appreciated the historical overview, and I had not previously known anything about how domestic relations worked before the Roman conquest.
We go back to children's time.
A slightly bigger question, which is, if I understand this draft right, at the top of page 2, essentially whether you terminate the guardianship is really one factor, best interest of the child,
Yes,
which is the standard you argued for.
absolutely.
Okay, so the real question is two prongs to the question. One is, as you're probably aware, Wyoming has a statute that says that the state must show a compelling state interest before it interferes with the parental rights, essentially.
Right.
So there's that. And then there's what appears to be the U.S. Supreme Court's last word on the subject in Troxel.
Correct.
So the overarching question is, if we pass this and take all of your suggestions, is it going to get struck down as unconstitutional?
Senator Medgar.
Mr. Chairman, thank you. I think it's important to understand procedurally for where a case would be when you're talking about termination of a guardianship requires a guardianship to already be legally authorized. And so the parent has either voluntarily surrendered the custody of their child to a guardian or has involuntarily done so after due process has been provided, requiring the showing of unfitness of the parent. And so procedurally where we are is the termination of that guardianship, which then requires the court to consider the fitness of the parent. But in addition, we are adding an additional due process step, in fact, to determine also the best interest of the child, going beyond just the simple question of the fitness of the parent.
Mr. Chairman, my question stands.
And my response, I agree with Senator Nethercutt's response, that we're in a different procedural posture, so that all of the due process rights have been afforded to the parent, where they have been voluntarily relinquished by voluntarily agreeing for another to step in. And the problem arises when we begin to see long periods of time where the child becomes attached to the caretaker guardian. And if we, my belief is that the parent has lost that right to assert a protected status under the Constitution. And that is because that protected status is afforded to fit parents who have not in any way allowed the state to intervene and then take over in terms of making child-rearing decisions, so that then we really have two individuals who are much more on equal plane, in my view. Now, I know that the parental rights are constitutionally protected, I have no question about that, but I am very interested in raising to the forefront and balancing the interests and recognizing the children as having a right to a safe, stable home. And that I don't feel that this is the same type of case that the Supreme Court has decided and used the broad language of the constitutionally protected right to care, custody, and control. It's already been ceded.
Mr. Chairman, I have a question if I may.
Yes, Senator.
Um, Is it true that the parental rights are not terminated in a guardianship? And so the parent is still the parent. It's just whoever has the physical decision making over that child through a guardianship is different than the parent in that circumstance.
Absolutely.
So the parent is still the constitutional parent in the guardianship.
That's true.
Thank you.
On the staff side, relative to this, page 2, kind of working through this page at a time as best we can. Input, how it fits, constitutionality.
Mr. Chairman, having just received these this afternoon, I'm hesitant to start any firm opinions. You know, I do wonder about including, association in that, how that would play into any constitutional rights, but without, looking at that a little more carefully, I'm hesitant to offer an opinion right now. I do, if my recollection is correct, my colleague correct me as well, but the court has looked at, the Iron Supreme Court has considered, parents' association with, for example, a criminal, girlfriend or boyfriend. It's one of the factors in considering, the best interest of the child, where the child should be.
Okay. Tori, you want
I won't correct Brian, but even recently as a few days ago, in a child custody dispute, of course that's slightly different. They consider association. There's certainly a personal associational issue that we would have to look at if we include that language. I think the parenthetical including the following is a non-exclusive list. It doesn't completely drive the topic that inquiry. So, like Brian said, the First Amendment associational rights issue is something that we have to look at.
All right, committee, any other discussion about page 2? All right, let's take a look over page 4. Impact of, and they're on new line 6, or line 6, impact of modifying guardianship on the order, including harm or detriment to the child if the guardianship is terminated. That additional new language. Any discussion, questions, concerns? Chair Olson, excuse me, Representative. 3 times you've been called. Senator Cochran.
Thank you. On line 5, or on page 5, the additional language, which of course we're just seeing for the first time today, but,
We're on page 5.
yes, it looks like there's an effort to establish a burden of proof here. Who has that burden of proof? And then establishing also substantial changes to it, which I think comes from the custody statute. And what I want to make sure we don't start doing is this do here with incorporating concepts and one of the statutory things, and that's what a substantial change in circumstances is. So I'm very curious as to how that would work in when we're already having an establishment of best interest and fitness guardianship. I don't want to turn this into a custody statute. I want to keep it as a guardianship statute, parental fitness and best interest of the child.
I certainly
Address the
understand.
chairman.
Oh, I'm sorry, Mr. Chairman. And second. My sense is that I was trying to find the proper language to remove this from a kind of a clear and convincing evidence that Representative Smith was talking about. And so I was thinking about it in that context of the custody situation as opposed to the guardianship determination per se. And my concern was if we left it at the best interest of the child, I was uncertain where the evidentiary burden would fall. If it would fall at preponderance of the evidence, if it would be a sense that each party carries, there is no burden. And so I was trying to actually maybe highlight that issue because, as you point out, maybe this isn't artful, but perhaps there's a better way to address that question.
Okay. Oh, Ryan, Representative Jennings.
Mr. Chairman, Doctor, do you find that a little bit subjective? I mean, the impact of modifying guardianship.
Do you have the mic next to you?
Do.
Turn it on.
The impact of modifying guardianship, including harm or detriment to the child, isn't that rather subjective? I mean, because life brings all kinds of things. And who makes that determination?
I do believe that the best interest of the child standard is often criticized from that perspective, that it is very hard to substitute one judge's determination. At the same time, when we're looking at the welfare of children, and there is a concern that taking them from a home where they have begun to put down roots, have friends, have stability, and moving them, that is often highly relevant in any type of a modification setting. And my thought was that if the question is not addressed, I think that's sort of what all the best interest factors are getting at. Is this going, what is the impact on this child? And so the thought was to think about harm, which can and often support, the ultimate determination. Do no harm.
Representative Olson.
Okay, I'm trying to walk through this impact of modifying guardianship on the one including harm of detriment.
You're back on page 4.
Yeah, I'm back.
Okay.
And maybe it's maybe it's all of these amendments together, because the analysis is the best interest of the child analysis. So what might be more helpful is to maybe if you could provide me with even a hypothetical of what you might present evidentiary-wise to a judge that I wouldn't already present in order to establish the best interest of the child. Why? Because I worry about these amendments unnecessarily making the statute wordy, complicated, and providing additional factors that already may be subsumed under the best interest of the child.
Chairman Christensen, Representative Wilson, I agree with you that the balance, the concern is, do we stay very broad and have a statute that says the court can consider anything, or do we give some guidance so that we have factors found on the record? So to the extent that there could be evidence of harm or detriment to the child, I agree it could overlap perhaps with if we brought in a psychologist's testimony and we talked about the impact on the psychological welfare of the child. And I believe that is covered in the ability of the parent and guardian to meet the child's physical, emotional, developmental, educational, and special needs. At the same time, I think the reason I thought about it was the importance of showing the roots that the child has established. But these were very friendly amendments, and I agree with you, it could come in under the social and emotional welfare.
Yes, Representative Pelkey.
I want to go back down to the bottom of page 5. What's your reasoning on the, because the parent has lost the presumption of fitness, the burden of proof should be clear and convincing evidence? Can you imagine a scenario where someone's child is in a guardianship where in fact that parent has other circumstances other than those that you've outlined, that in fact the parent has not lost the presumption of fitness, that there may be health circumstances,
An illness.
I had cancer a few years ago. If I had been hospitalized for an extensive period of time, I still had minor children in the house. That wouldn't have affected my fitness as a parent, but I may have been grateful for somebody to be in a guardianship position. I'm not sure this language is necessary, and I'm just curious what you're thinking was when you did that.
Certainly. Chairman Christensen, Representative Pelkey. My thinking was, again, struggling with the issue of the burden of proof and having sort of three choices. That there would be no burden of proof, simply a best interest determination, burden of proof on the guardian, or burden of proof on the party moving for the change. And I thought it made sense to place that burden on the party moving for change, and then it just came down to, is it a preponderance? What is the standard? So that was my thinking, and by choosing that clear and convincing evidence standard, it certainly favors the guardian. And so that was the discussion with the Wyoming guardians as protectors. But I certainly believe in the hypothetical that you just gave, that should be a situation where the party would be able to put on evidence and show that they, had never, that they're ready for the kids to come home and that there wasn't a finding of fitness or unfitness. And I think that's expressed in the statute for that purpose. So I agree with you that that does not work well in your head.
Brian?
Mr. Chairman, I believe I can answer Representative Pelkey's question. In re-SRB, the Wyoming Supreme Court case was that situation. I believe what had happened was the mother was convicted of a crime, petitioned or had a voluntary guardianship entered. When the parent was released from incarceration, complying with the terms of parole, she sought termination of the guardianship. What the Supreme Court said was, because the mother was never judged to be unfit, she did not, upon petitioning for terminating the guardianship, have to prove that she was now fit. All the mother had to do was prove that whatever conditions or whatever the situation was that led to the guardianship being necessary were no longer necessary. And after that, the burden was on the guardian to prove that the parent was unfit.
Okay, thank you. All right, let's turn over to, is that it? That's it. Got through those, 2, 4, and 5. Sounds like there's some concerns about necessary, unnecessary, and recognizing the intent, but some of the challenges. So as I listen to some of the comments, reflect back on conversations on the floor of the Senate, it's very, I can rapidly see this, I recall conversations like this coming apart based on those factors. All right. So, Jim.
Rofio.
Yes, that's what I said.
You did.
No.
Chairman Christensen and committee members, thank you for having us. My name is Dr. Jim Barofio. I'm a licensed psychologist in Colorado as well as Texas. The Guardians contacted me to provide an opinion with respect to psychological variables based on my 30 years of experience working in child protection, child welfare, and working with the social, emotional, behavioral disturbances of children as well as adults. oftentimes in relation to, typically at times in relation to disrupted attachment. Ultimately, I'm in support of this bill, this proposed bill, primarily because what it does is seem to incorporate much of what we've learned since the 18th century with respect to best interests of the child. In particular, it addresses the importance of attachment, and attachment as a core element, critical element in the psychological well-being and psychological development of children. It also addresses the importance of understanding disrupted attachment, the significant damage that occurs by way of disrupted attachment. You just comment briefly on those two elements. Fundamentally, our understanding of attachment comes from our understanding of what happens when attachment has been disrupted. So the early theorists, the early researchers analyzed disrupted attachment, came to understand that attachment is a core element. Some would even go so far as to say inherent in the psychological survival of children, in terms of how they organize their psychological lives, how they begin to develop regulatory mechanisms. Since that time, we've developed an understanding of the neurobiology associated with attachment, that attachment is critical in the appropriate development of neuropsychological structures in children. Essentially, it lays the foundation for a child's ability to formulate functional relationships with others, to develop a functional psychological sense of self, to develop self-regulatory mechanisms, and ultimately to organize themselves. So I think this bill addresses that. I think the other element that's of critical importance here is that we can also see that biological filiation is neither necessary nor sufficient with respect to attachment. Children attach to those who organize around them and organize them, who are present psychologically, join their psychological worlds. So I think then this bill goes further and allows us to understand the critical role of a psychological parent in a child's life. That children attach to those who are fundamentally available to them, provide the psychological support, the necessary nurturing, the developmental facilitation, and then ultimately can affectively attune and organize that child. Children learn first from the outside in. Only with proper outside-in learning experiences can children learn from the inside out.
Yes.
Thank you so much for your testimony as well. I know that psychological definitions can expand over time. How subjective a term is disruptive attachment?
Mr. Chairman and Representative Winters, ultimately disrupted attachment is well known in the clinical literature. It's well established as a construct. That construct, speaking specifically to the experience of a child with respect to loss, separation, and ultimately elements of overwhelming grief. So it is actually a well understood construct. I think that it's not fuzzy in many respects. I think the fuzziness comes more in terms of certain laypersons' interpretation of that, but clinically, it's a well-established construct.
Thank you.
Other questions? Yes.
Thank you, Mr. Co-Chairman. One of the concerns that was expressed in May is how damaging it is to jerk the child away from the, we'll call them the grandparent, realizing he's not, and bring them back in relationship with the biological parents. So assuming that the biological parent wins the day in this hearing and begins to get the child back, is the language at the bottom of 4, paragraph 1, and top of page 5, paragraph 2, is that sufficient in your mind to allow for a gradual taking away the child from the grandparent and putting them back to the original focus? Did we accomplish what we want to accomplish in providing, I guess, a gradual change there? Go ahead.
Mr. Chairman, Representative Kirkbride, it's a terrific question, and it's actually the question that I'm asked on the stand quite often. I think that the language is adequate in the sense that we have to formulate an appropriate, graduated plan of action. I think where things become substantively complicated clinically is when there's an abrupt discontinuation of the attachment relationship. I think that with proper intervention, with a systematic and organized approach to not just reducing the attachment relationship that you have, for example, with a grandparent here, but actually also working on facilitating an appropriate relationship and an appropriate attachment to that biological parent. Those things have to be done together. So I think actually having this sort of language in here is critical. Sufficient.
Okay. Yes, Representative Olson.
Thank you, Mr. Chairman. Doctor, you talked a lot about attachment theory, and I'm curious whether there are maybe other things in the hierarchy, or if this is in fact the top of the hierarchy. I'm thinking of things like consistency, predictability, for one, where you would rank those type of things in relation to attachment, but also my second question would be more specifically to address this attachment theory versus biology, and whether if you could, I don't know exactly how to ask this question, but you said something to the extent of biology matters less, and we find that a child is going to attach to whomever almost through a time element factor. Could be anyone. But I'm curious how that truly stacks up against biology. And I guess maybe I'm just a simple person, but I think that a child would have a biological, natural attachment to its parent. Period.
Mr. Chairman.
Please.
Representative Olson, another good question. First of all, let me make the statement that we refer to attachment theory, but really it is attachment as a construct is a body of facts, and it's informed by various disciplines: ethnology, anthropology, psychology, and biology. Let me clarify one comment that I made, and that is that biological filiation is neither necessary nor sufficient for attachment. What that means, breaking that down a bit, that fundamentally means is that simply because there's a biological connection, that does not in any way, shape, or form mean that the child is going to attach to that particular person. It really has far more to do with the behaviors, the organizing influences, consistency as you spoke to, and the stability of that particular person. In that context, there's no scientific evidence that a child has some sort of innate or inherent biological response to a biological parent. Children fundamentally attach to those who are most readily available. We see that not only with humans, but we see that across species as well. So attachment is well understood. You think about, for example, Conrad Lorenz's imprinting studies, where he was followed around by ducklings. So what this means is that there is a biological press, a reflex to engage in attachment, but it doesn't necessarily have to be the biological parent. It is the primary caretaker, that attachment object for this particular any particular child.
Chair.
Yes, sir.
Thank you, Mr. Chairman. I had a quick question for you, Doctor. I come from a military background. We've gone through the last few years with a lot of high-tempo deployments. I was a commander where many of my soldiers were deployed for 2 to 3 years with maybe luckily 6 months in between. A lot of those families, mothers gave birth while the husband was in theater, either in Iraq or Afghanistan. So the child up to age 2 or 3 had almost no contact with the biological father. I'm having trouble, though, seeing the father get off the plane, seeing the 3-year-old run to the parent without any biological attachment issues. Can you expound on that for me? Can you help me with that theory?
Mr. Chairman, Representative Salazar, I echo your concerns. Candidly, I was an Army reservist officer, and I continue to work extensively with the VA system, as well as service members. It is a challenge, and if I understand your question correctly, it sounds as though you're asking, what about those individuals who have had no involvement in the very early, very formative and critical times in a child's life? What happens in terms of attachment to those particular individuals? Is that what you're asking me? Okay. So, fundamentally, my experience has been, many of those children have an awareness of this potentially available attachment figure, that being the deployed parent. They've been exposed to that by virtue of video conferencing, the narration of the family system, explaining who this person is. That may create certain expectations for that particular child. I think what has to happen, however, is that child has to progressively develop an attachment. There's no scientific evidence that child inherently has an attachment to that person. They have to go through a process of learning how to be relevant to one another, how to have those reference points to one another, how to experience one another in relationship. That is something that can certainly be done. It is a process and not an event. My position there is that certainly that becomes part of this restorative process of creating engagement and learning how to attach and relate for that particular child and that particular parent.
Any other questions? Doctor? Yes, Representative Jennings.
Mr. Chairman, thank you. So there's no evidence, scientific evidence for attachment. Is there any scientific evidence against biological?
Mr. Chairman, Representative Jennings, there's actually considerable scientific evidence for attachment. We know that. What I think I was referring to, perhaps what you heard me say, was that there's no scientific evidence for inherently biological filiation and attachment. It's really, for example, you can have a child who is being raised by the biological parent, and that child can have an attachment disorder. They can have disrupted attachment even with that biological parent. It really has to do with what that biological parent does. And this gets us into the realm of parents who are abusing substances. Drug abuse is a significant disruptor for attachment, even with biological parents. The reason for that is because it creates instability. It creates psychological instability. It creates altered states of consciousness, making it very difficult for that parent to functionally engage that child and provide the bonding experiences that would be necessary for attachment.
So, Doc, when you talk about drug addiction and disruptor, and I see in the bill language here the suggested amendments to talk about habitual drug addiction. We're going to go there. Do we need to include alcoholism?
Certainly, Mr. Chairman, certainly I think alcohol abuse can also be a significant disruptor. I think that is another element that needs to be considered. I think what's also important to bear in mind is that the great majority of individuals with alcohol misuse problems have some co-occurring mental health elements as well. So that needs to be considered as sort of a broad array of issues and co-occurring problems.
Mr. Chairman, Doctor, I really appreciate the opportunity to really learn from what you're saying. Help me to understand if I'm on the right track. I'm just a layman in this subject. As a pastor doing some of the counseling I've done, I do understand that there is initially, at least, a biological relationship between the right brain. I think it's Dr. Bowlby who brought that up initially, and then there's a Dr. Scholl that elucidated some of it. What you're saying, though, is that initial biological connection between the parent and child is disrupted. That's what we're trying to address. So you're not denying that there is both a biological as well as psychological connection initially, right? You'd be speaking of something that is disrupting it for some other reason. And that's the reason why we're trying to address the issue. Is that, am I on the right track? I'm enjoying the opportunity to learn from you.
Mr. Chairman, Representative Winters, largely, yes.
Okay.
I think what Bowlby spoke to, and then his contemporary Ainsworth, the body of their research. By the way, the body of their research began with understanding children in orphanages in England during World War II. And so what that research was able to elucidate was that certainly children have a biological propensity, innate drive, sort of a reflex to attach. Most parents have a reflex to attach as well. One only has to really look at, how silly we sometimes look with infants. All those are attachment-oriented behaviors, and attachment really is a bi-directional process. Not only do children attach to parents, but parents attach to children. And that's where the magic really occurs, clinically speaking. Now, when that process is disrupted, it can be disrupted by a variety of things. Absence, mental illness, mental disturbances on the part of parents, substance abuse. It doesn't mean that the child's reflex goes away. The child still has that reflex, and most importantly, that child has that need, because attachment is what ensures initially the physical survival of the child, and then eventually the psychological survival and development of the child. But that disruption itself can cause significant anomalies and atypicalities in the development of that child. As that child develops a sense of there's sort of an other out there that provides various forms of support and nurturing and organizing. And I think that disrupted event is what causes the atypicalities with respect to emotional regulation, cognitive development, and as we know, certain aspects of neurobiological and neuropsychological disturbance.
All right, we need to get back on the bill. Okay. Not that this isn't really, but relative to the bill, relative to the written testimony, and guys who's expressed questions of these two witnesses. Any further? Thank you very much. Appreciate your time. Appreciate you joining us, and hope you're able to stick with a few minutes to work through further discussion. Let's go ahead and start with state agencies that may have input. State agencies have input on this. Oh, yes. Sure.
I'm Lily Sharp. I'm the state court administrator. Judge Day had to leave to head back to Jackson, but asked that I add one or give you one, his own input. He asked to tell you that it is not the input of the district court judges, but it's his personal input from his own work as a district court judge. And he said, what he asked is to give you an example of a situation in which he believes that this bill would be very beneficial to a district court judge. He said, take an example of a mom who's 17, she's unwed, she is pregnant, and she doesn't know who the father is. Her grandma She has a grandma in the same location, in the same town that she is. She has the baby. The grandma, from the time the baby is born, takes it becomes a guardian voluntarily becomes a guardian for the baby. The mom then moves to Oklahoma. She marries a man who is 15 years older than she is. That man has 3 children, and then she gets pregnant and has another baby with that father. The grandma, now the baby is, by this time the baby's 7, 8, 9 years old. And what he said is under the difficulty with this situation is under the framework of INRI SRB, if the biological parent is fit, that is basically can meet the basic needs of the child, there is almost an irrebuttable presumption that the child will need to go back to the mom. And it never gets to the best interest of the child. Unless, he said, there are very extraordinary circumstances, the judge must terminate that guardianship. And he just asked me to let you know that this bill, in his own personal opinion, provides a situation to address this difficult situation that is much needed.
Thank you. Any questions, Ms. Sharp? Senator Hicks, hold on, wait, please. For you.
Me?
If you would.
So Mrs. Sharp, under that analysis, when we look at the ruling on the case of the Supreme Court, which basically said regardless of the best interest of the child, it is always going to come back to the fitness of the parents issue. How does this play into that issue? So when we look at the Supreme Court case, trying to see which one this was. 2006 case, basically they ruled that the guardianship had to be terminated and final rights restored because of fundamental constitutional rights of the parents overrode the best interest of the child. Under that decision, the court quoted, because it did not find the mother unfit as a parent, the district court's determination that the guardianship was necessary based solely upon the best interest analysis was clearly erroneous. The district court's appointment of grandparents is reversed. What I'm grappling with this is, even if we enacted this legislation, the Supreme Court's court precedents now to say that irregardless of what the best interest of the child is, as long as that parent has not been proved to be unfit, that they're going to get the custodianship. So I'm trying to figure out where this piece of legislation addresses this issue. Because it looks to me as like we're just kind of hanging more flowers on this thing and we're not going to accomplish it. Can you comment on that? I mean, how does going through this whole analysis and determination address the issue that the Supreme Court says it's the fundamental right of the parent unless we prove the parent's unfit? It doesn't matter what the best interest of the child is.
Mr. Chairman, and at
This
this
is a little outside your.
I would turn that over to LSO to answer those technical questions.
Thank you. Sorry, Senator Hicks. You probably had the answer.
Mr. Chairman, I just wanted to key up the opportunity for our LSO staff to contemplate the answers to the question.
To the staff, are you prepared to make a response at this point on that particular question?
Mr. Chairman, I can. I've been advised by legislative counsel not to make any commitments. I don't think I'm so.
In all seriousness, so be able to capture the question and the issue Sounds like that's something you have to grapple with.
Mr. Chairman, I think that's correct. What I will say in response, Mr. Chairman, Senator Hicks, is that for a guardianship to be established, the court in that same case said there has to be a necessity. So there has to be some reason for that guardianship to be established, whether it's voluntary, the parent has decided that there's some necessity, or because the parent is found unfit. So what this bill draft would do is, in addition to that question, add these factors that a court would consider, keeping in mind that the framework underlying that is there is a guardianship in place, which means that at one point the parent was unfit or there's some necessity for the guardianship. I'm not sure, Mr. Chairman, Senator Hicks, if that's getting to your question or not.
Senator Hicks.
Yeah, Mr. Chairman, and I think that to a certain degree makes sense, but if we go through that logical progression, that there's already this is appropriate assignment of guardianship. This looks to me like it actually starts to complicate the ability of the courts to make a determination of appropriate guardianship with adding all these extra layers in there versus the current procedures.
Senator Nevicut.
Thank you, Mr. Chairman. Just ownership over this, because I directed it, so
Turn the honors
I don't think the batteries are down yet. Right now. So I think what we can recall from hearing from the district court judges in Moreland and what the frustration we heard from so many members of the audience at each, both last year during session, last interim committee, and this interim committee time, is that there's an inability for the courts under a guardianship framework to determine what really is in the best interest of the child. And in fact, the child's interests aren't even considered, to the harm of the children, to the significant harm of the children. And so what this goes to solve is to give a tool to the courts and to the parties involved, including both parents and guardians and the children who are the subject of this entire debate, the opportunity to evaluate those issues, which is what I would just encourage you to recognize what the courts have asked to do. The cases that you were reading, I'm not sure where that packet of case law came from that's on our materials. Did that come from LSO or where did that come from? That MBO case?
The multicolored sheet that's highlighted.
It's highlighted.
Back of the room.
Okay. Yeah, we're cherry picking cases out and kind of reading that in a dangerous way. I think it's important to understand that those cases have also been interpreted pre this legislation being enacted. And once this legislation is enacted, it specifically directs the court to still make a determination regarding parental fitness, but also consider the best interest of the child. So let's say, for example, that a court says, you know what, you are out of prison, you are back in rehab, you're doing well, you are fit. But instead of just saying, right now, we're gonna surrender the child who hasn't seen you for 9 years into your care, because you have a 2-bedroom apartment, we're gonna start the process of integration and we're gonna do a visitation schedule because I have the authority to do that because I think that's actually in the best interest of the child. And so we'll start that process through in order to make this an easier transition, recognizing that parent's constitutional right, which still exists. Keep in mind that when we're passing this type of legislation, it doesn't trump constitutional rights. Those still exist and the court still has to balance those within this guardianship framework. And so for the November meeting, I'd ask LSO to have a greater understanding of that so we can address those concerns. And it's just an understanding of where families are, where children are at a time when these particular guardianships would be challenged and requested to be terminated. Recognizing we have both a duty to parents in this state as well as the children.
Representative Six, so we need to.
Thank you, Mr. Chairman. To me, this bill concerning the termination of a guardianship is the mirror image of the next bill we consider, which is de facto guardianship. When would you grant? Okay, I'll get the point then. On that, it is my concern whatever bill we pass has constitutional muster. And in Trump's role, what the US Supreme Court in its plurality opinion seemed to say was that one of the defective parts of the Washington state statute at issue there was that there was no showing of probable harm to the child. So one of the proposed amendments from the professor that I like is the one that deals with the determination of whether there's harm to the child. I think that could be important to have that as a factor in this proposed bill to ensure that it's constitutional. And I think it's also important that we pass laws or pass bills that also don't contradict other legislation that we've already passed. We've got on the books that if the government does something that interferes with the parental right, that you have to show a compelling state interest. So I think we have to incorporate something about a compelling state interest in this bill, or it will just be in conflict with another statute that we already have on the books. And I also think passage of the child is a relevant factor, should be a relevant factor in termination of guardianship. So the amendment that I propose that shows up in the draft of the next bill that I guess we're not going to consider has those three factors that you have to consider. So I think if we pass this bill as drafted right now, I'm very concerned that it would just get struck down as unconstitutional, as Senator Hicks said was concerned about as well.
All right.
Mr. Chairman, if I may appeal to you, I'm confused. I don't know if we're in public comment anymore or we're talking about a bill that we have to move.
We have not brought it back yet. We are still having some general discussion. It's a rollover to our expert witnesses and agency. This came out of Senator Hicks' question. Then went to staff, and now we're going back and forth. So that's how we get to where we are. But it is after 5 o'clock. I know there's some of you that may be thinking about hitting the road. My intent is to wrap this up, not to take a formal vote on it, but instead, because of the suggestion of amendments, take a general vote on moving the bill forward to be drafted and then going into voting on possible amendments for LSO to work on. And so if you need to leave, we'll be working on majority votes, not on individual body vote for final motion going forward. And if you can stay, we'll move along with a quick pace. But just because we're after 5 o'clock and there's some concerns, let you know how we're moving forward. Yes. Cory.
Just by way of more information, Brian actually has written 2 memos on constitutionality issues. They're both in the package of the last meeting. One written for Portland, one written. It perhaps doesn't address directly Senator Hicks' question, but encouraging it down with other people. And I guess encourage you to get more specific pointed questions about that. Fundamentally, those Wine Supreme Court cases looked at the statutory language. Guardianship statutes found that the term necessity required unfitness. They used Troxel to talk about the requirement of unfitness. And, all kidding aside, this bill is a scheme to address that issue, which contain constitutional considerations in parent and child's rights. LSO doesn't have an opinion about how a court would ultimately rule in deciding which constitutional rights would prevail. So that's something that is important for the committee to understand, that this is somewhat uncharted water, at least in Wyoming. As Brian noted, reflects there are other states that have adopted variations of that guardianship bill, and a number of them have deemed it constitutional.
Whether our Supreme Court would find the same way, we can't say. I want to put that response to Senator Case's question. Thank you. Is there any other agency comment or input? All right, we're going to open this up to the public, and I'm going to ask for 2 minutes. And we're going to keep it very short. The reason we're doing that is we have heard a number of different really important accounts of how this has impacted children and families and grandparents and supporters in several meetings. So for tonight, if you have something new to add, if you keep it very condensed so that we can then bring this topic back to the committee. And when we bring it back to committee, then we'll go into committee discussion, see where it all ends up at. Representative Ms. Jennings.
Mr. Chairman, I'd like to ask a question of, is there a lawyer here? I'd like to ask a question, probably going back to Senator Hicks, that for clarification, I think maybe for the entire committee, we keep hearing the fitness or the
Can we hold that until we get to committee discussion?
best interest of the child. But when a court is determining fitness of a parent, isn't that part of the consideration of making a determination for fitness of the parent? The best interest of the child is part of that equation. To some lawyer, any lawyer?
Let's give LSO a little bit of time to think about that, and if anybody would like to use their time to address that question, then we'll bring this back to the committee. That was your question. Thanks. All right, again, public comment, if you can limit it to 2 minutes, so we can get through everybody. Let me ask first, how many people would like to speak? So far, only 3? Okay. All right, ma'am, you can come up and address the chair, state your name, any affiliations you have, or if you're representing an organization.
My name is Linda Denison. I'm with Andy Protecting Children.
Sorry.
My name is Linda Denison. I'm with Andy, who's got that work going out.
You're welcome to have a seat. Be close to the mic.
This one work?
Listen. I don't know if it worked or not. Is there a green light on the top of the device?
No. Nope.
Well, I don't know what's turned out there. All batteries are.
Yeah, battery's dead.
Oh, yeah.
Does this microphone work still? Is this a big mic? Yeah, just speak into the big mic. Or in one of the 3.
My name is Linda Denison, and I'm here for the protection of the children. And Andy. I have 2 grandbabies. Right. When I got them, the youngest one was 8 months. The older one was 4 years. They were left in a basement by themselves. They had water on the floor and bugs. And the kids would tell me of the stories of everything going on. Had it for 6 years and I'm in my 7th year with them. The parents have not had any contact with him. The baby was never held by his mother. She called me up and told me the baby was born, so I was the first one that held him. He was using drugs and alcohol. Kids were neglected. When he got here from the East Coast, baby was dehydrated, malnutritious, and a little boy that was 4 could not speak anything. He had his own sign language. So we took him in, took care of him. They made great strides in growing up and everything, but the youngest one has some issues because he has fetal alcohol, other issues going on in his body. He's made a change. He didn't know how to eat when we got here, drink a bottle and nothing else. So if they ever came and took the kids away from us, the kids would just, they wouldn't go. Artie told his mother to go away, he don't belong here. That he was 4 years old when he said that. And baby's never known his mother. as far as he knows, I'm out. So we need something to protect the children. They have a constitutional right also. Not only the parents gave them up. We as parents are supposed to teach them. These parents neglected them. So that's,
Thank you very much. All right.
Mr. Chairman, my name is Jan Loftus. I volunteer as the state coordinator for parentalrights.org. And a few additions that those court cases were, or that court case is mine that has the different colors. The U.S. Supreme Court is referenced in this case, so that the pink is a U.S. Supreme Court case. I want to clarify that. That case, Santoski went on to say further, until the state proves parental unfitness, the child and his parents share a vital interest in preventing erroneous termination of their natural relationship, a shared relationship between parent and child. In addition, another U.S. Supreme Court case, Washington v. Glucksberg, 1997, the court said in a long line of cases, we have held that in addition to the specific freedoms protected by the Bill of Rights, the liberties specially protected by the Due Process Clause includes the rights to direct the education and upbringing of one's children. The 14th Amendment forbids the government to infringe fundamental liberty interests of all, no matter what process is provided, unless the infringement is narrowly tailored to serve a compelling state interest. The law that the legislature passed last year and the governor signed into law is a fundamental right. And fundamental rights require that the burden of proof is on the state, not on the individual. And that is a difference with a fundamental right as to lower rights. The burden of proof is on the person. But the state is required to prove unfitness with a fundamental right. And through the years, the Supreme Court has called parental rights fundamental rights. A little bit into theory that the bond between parents and children are really important and powerful. And this relationship the policies that affect it have profound impacts on our society. So I appreciate that you're taking all this time. One last thing is the encroachment of this reinterpretation of best interests would be the family court equivalent of guilty until proven innocent.
Thank you very much. Hold on one second. Representative Smith.
Mr. Chairman, I just wanted to ask a question. So what would you say to the woman who testified a moment ago? Let's imagine the biological parent shows up, not having been there for 7 years or so, and says, I just got out of residential treatment, I feel better now, I can go with my kid, and you can't see the kid. What do you say, what do you think the right answer is?
Mr. Chairman. In our termination of parental rights statute, I believe 14-2-309, there is similar language as in the DeFacto bill already that if the child has been left in the care of another person without provision for the child's support and without communication from the absent parent for a period of at least 1 year, that is, it goes on further, but in the interest of time, that is grounds for termination. Perhaps after several years, termination is in most cases.
All right, thank you. Sir?
Thank you, Mr. Chairman, and committee members. My name is Tom Schmidt. I live here in Laramie. I represent myself. Tom Schmidt. I live here in Laramie. I represent just myself. And when I see bills like this, I'm kind of reminded that there's always a tension between people and the governments they create. And that in time, it seems like people always become the inferior party to the action of the party of the state. And I guess people forget who they are, and the government forgets the role that they're supposed to play in this. And I believe life should be on a two-way street. And by that I mean, so you go in and talk to the IRS or the FBI or something, and they'll warn you that if you lie to them, it's a crime or a penalty. But when I ask them the same question, there's always silence. There never seems to be a penalty if they do. So that's when the meeting's over for me. And I believe it has to be that way between state and people. And too many times, the parents become the inferior party in a lot of actions I've seen over the years. And I want to wrap this up real quick. I'm not really willing to give up my rights as a parent along with its responsibilities and duties over people who have neglected their duties and responsibilities. Which may seem harsh, but a lot of life is harsh. And I believe in maintaining my duties and responsibilities as a parent. And I'm not willing to give up that right when other people relinquish their rights and duties and their responsibilities. Thank you very much.
Thank you. Further public comment?
I'd just like to make a comment.
Come on up and introduce yourself. Stand, go to kind of the center by the microphones.
So my name is Art Huckfeld, and I'm with Wyoming Groups as Protectors, and most of you guys have heard from me before. My instance, I had the children for almost 12 years. And I'm just gonna make this really short. I told you last time that I'm that parent of that child. The parents gave up that right when they abandoned that child, and our statutes say that when you abandon a child, that proves unfitness. Our statutes also say when you're a drug user, you are unfit until you prove yourself no longer a drug user. In my case, the judge decided to put those children back with that mother within 2 months. That mother was picked up with 51 grams of methamphetamine, and now the daughter that the judge put back with that mother is on methamphetamine. We gotta protect the kids, guys.
Any other public comment? Annie, would you like to say anything?
Thank you for indulging us all our time. Chair. All I have to say is that
For the record,
Annie McLaughlin. I am extremely thankful for our two guests, and of course, I'm thankful for all of you, because I know that you're good people. My own people, good people. There's been a lot of discussion about constitutionalism, but we have to remember that over half of the nation now has passed these types of laws. There may be different nuances, we can call it. Thank you, Senator Mandicott, from the bottom of our heart, for all your hard work. But irregardless, there is a common thread among these states that have passed this law. And in all due respect, Senator Hicks, I have.
let's just address the chair. We don't want to go into
Well,
individual
that comment about the constitutional, every single state where this type of law has been challenged, it hasn't been challenged in Wyoming, but it has been upheld by the state Supreme Court. We have talked to 5 judges now, all of which have told us this needs to pass. Our last presentation that we did in Northern, a judge came up to us, and his exact words were, "Wrapping our hand, I'm 110% behind this. You don't have to explain. I understand the situation. I wish you the very best of luck." at every juncture. And again, let's remember that we're not talking about military, we're talking about a drug epidemic primarily and associated criminal behavior, that dark world that causes these parents to leave these children with us for, most of us, for years. That's what this is about. And it's about the attachment that is formed. And we have to have laws that say, protect these children and don't rip them out of their family unit, because this is their family unit. I wish in a perfect world that people would go to rehab. These are our children that were challenging me. My daughter, one of my 3 daughters, I love her, but she's chosen to get high for 30 years. She has 4 children. The state of Wyoming terminated her rights in Sundance, 2 of them. So this is about drugs. This is about parents doing habitual drug use primarily. And what are we going to do to protect the children? What clear guidelines are you all going to put into this bill that gives the judge the tools that they beg you for? And that's all I have to say. And you, thank you, because I know you want to get out of here. God bless you.
Thank you. Any other public comment? We're about to close public comment. If you would like to speak, this is your time. Okay. All right, back to the committee. We have a bill in front of us that has been proposed. We've had a few different amendments that have been proposed by the audience. And so at this point, I think what we're going to do is take a majority. We can talk first if you'd like, but ask for a vote on, going to be a majority vote to have staff go ahead and take the language forward. The reason I'm doing that is so then we can talk about individual amendments, make sure they're clear. If any of them pass, for the staff, prepare the bill. So,
Mr. Chairman, yes, if you could explain, I'm confused why we're doing this process. So earlier in the day today, we had a series of bills that we sent to vote on. We had one of those bills which had a slew of amendments brought. And we had to make a decision on whether we were going to move any of those amendments or not. So I'm confused why we're not walking through that same process. For example, the bill in front of us is a bunch of amendments. If this body isn't even interested in those amendments.
I was hoping, that's just an idea.
Well, what if this body isn't interested in the amendments?
And you can propose amendments, vote it up or down, just so we're clear on it, because we do have written amendments ahead of us.
Right.
If you would like to just ask them to try to figure out the amendments, but I've heard yourself, you had concern about some of the proposed amendments. So rather than just ask staff to incorporate them or bring them up, we can dispose of them now.
That's kind of what I'm suggesting. And Mr. Chairman, maybe if this committee quickly realizes that that's going to be a long endeavor, then I can understand the process that you suggested. But it may not be a quick endeavor. You may be able to address this bill now.
How about everybody in favor of this was a voice vote. Everybody in favor of LSO bringing the bill forward and preparing it for November discussion, say aye.
Aye.
Opposed? Okay. No. The ayes have it. Individual amendments to the bill for LSO to prepare, and they may have to refine them. Anybody have any individual amendments for LSO? And we'll vote on this.
Mr. Chairman.
Yes, Representative Phelps.
I'd like to propose maybe something a little bit different from that, is that there's significant amended language proposed here, and what I'd like to ask LSO to do is prepare those as separate amendments to be presented to us in November. There's some elements of this suggested modification that I like, but I think it's pretty clear that that provision on presumption of fitness and burden of proof is something I'm not particularly comfortable with. So what I'd like to do is in November, get those separate
amendments, and we can actually talk about the ramifications of what it is we're dealing with, rather than suggesting that you try to incorporate that language in the body of the bill for November.
I might not be clear on what I'm saying. What I'm suggesting is that we make a motion on what you like, and other people make motions on what they like, and vote them up or down. You know, you like part of it, you don't like part of it. Does that work? And part of this is it keeps it clear for us, so what they're gonna do, rather than to try and find which goes with which. We started out working this page at a time, and there was concern about the overall, how all the amendments work together.
Well, Mr. Chairman, I respect that. I think that it would be, if we did that today in that fashion, it would be somewhat hurried. What I'm suggesting is that some of these proposals will take some consideration and some discussion.
Your motion is everything that's handwritten is one amendment.
It's a series of amendments that can be attached to the bill for us to discuss.
Okay, we have a motion. We have a second. Question? Second. Oh, speak up. All right. We have a motion and a second that these are all individual amendments and we're talking about the ones that are handwritten. How do you, this staff, how are you going to separate those? Are you just going to do them line by line or paragraph by paragraph?
Mr. Chairman, I think what we would probably do, based on what I understand from Representative Pelkey, is a separate document that has the amendments line by line. We can somehow show, which amendment was on page 2, which one was page 4, separate them by some way.
There's your motion, your amendment, opposed amendment. All in favor, say aye.
Aye.
Opposed?
No.
Hands for aye. 1.
This would be to advance, to November, so we can discuss.
4 hands, 4 ayes, noes. Noes have it. Got any other amendments? Any other amendments? Now keep in mind that when we come back in November, it'll work the bill. It's not the final status. Any other proposed amendments based on testimony, on your particular insights? Okay. We got a motion, been seconded to bring this bill as we've already prepared it forward for November without any opposed amendments. With that, all in favor, say aye.
Aye.
Opposed? No. Hands up for ayes. 1, 2, 3, 4, 5, 6, 7. The noes? 1, 2, 3, 4. 5. 5 to 7.
The majority of both bodies, Mr. Chairman?
No, that's
Simple majority. This is just.
This is the majority. If it was to go split or to kill it, then we go for a vote. Roll call. Right now, the vote is to move the bill forward, and we'll work on it in November. And I'm not seeing any changes. Just bring it back to us and we'll continue the conversation. Okay? All right. Is there any, as you probably comment at every event as we move through it, the staff, questions of us over the last 2 days? Please go easy on us.
Mr. Chairman, I don't think we have any questions for the committee. We'll certainly be in contact with CSG and work through their bill draft recommendations. We'll contact the chairman if we need to discuss it.
How many bills are we going to be looking at in November?
I think the preliminary count is 10.
folks, we're able to vote on a few of them, but we've still got 10 bills ahead of us to talk about in November. Plenty to do. Thank you all for joining us and spending 2 days with us, for those of you who did it or those who were able to come today. Thank you to the committee. Thank you to staff. Travel safe. And we will see you in a short. Oh, yeah, I've got to sign. Has everybody got their vouchers turned in?